Hello everyone, I think we're ready to start. Welcome to today's discussion on immigration options for scientists and researchers, what employers need to know. My name is Philomena Lepore and I'm an attorney here at Gibney in the Immigration Practice Group. I'm very fortunate today to be joined by my colleagues Aisling Ryan and Survi Parvatyar. Aisling and Survi are also attorneys in our Immigration Practice Group with experience assisting scientists and researchers in their U.S. immigration journeys. Today they're going to guide us through some of the temporary U.S. visa options available to scientists and researchers, and I'm going to provide some background on immigration basics. I'm also going to be discussing U.S. permanent resident options, also known as the green card options, that are available to scientists and researchers. Now, wouldn't it be nice if we lived in a world where scientists and researchers were welcomed to the U.S. with open arms simply by virtue of their vast knowledge and talent? Well, today we're going to discuss some scenarios where this actually might be the case, as well as the way more common scenarios in which scientists and their employers are left to navigate a very complex immigration system. We hope to address the challenges that many of you face and to propose some practical solutions to those challenges. As we progress through the presentation, we encourage you to review the chart of common temporary visa options for scientists that we've included at the very end of the slide deck that you can download as a PDF. The chart lists in detail the different U.S. visa types and the eligibility criteria for each, so we really hope you find it useful as a quick reference guide. In case we do not address all of the issues today, which I'm sure we won't, we will leave time at the end for questions. So without more, why don't I go ahead and start us off with a brief and basic overview of the different immigration paths that one might take to achieve work authorization in the United States. Okay. So as you can see on our slide here, at the beginning of an employment relationship, most employers will explore a temporary visa option for prospective foreign national employees. In the legal world, we call these temporary visas non-immigrant visas. And these refer to the alphabet soup that I'm sure many of you have heard, the F1, the J1, the O1, the H1B. The list goes on and on. The important things to remember about non-immigrant visas are that first, they are temporary in nature and thus allow individuals to remain in the U.S. for a set period of time. Many of these visas also require an explicit temporary intent, meaning the visa holder must intend to return to his or her home country at the conclusion of the work assignment. In addition to temporary intent, non-immigrant visas require a sponsor, such as an employer, an institution, or a school, and they also require a specific job offer. Now, another pathway to the U.S. is coming here in a more permanent manner, that is, on a green card or what we call the immigrant visa. Individuals can attain a green card either through employer sponsorship, the sponsorship of a qualifying family member, or in limited cases that are particularly relevant to scientists, through self-sponsorship. When someone has a green card, they can remain in the U.S. indefinitely and have unrestricted work authorization, meaning they do not need to work for a specified employer sponsor or in a specified job. In fact, they really don't even need to work at all. To maintain the green card, individuals must maintain an intent to reside in the U.S. indefinitely. From an employer perspective, green card holders are very desirable because they don't require ongoing maintenance of their visa status. This means they can switch to different job functions or locations without the need to take any visa action, and they do not need to apply for extensions of their work authorization. Now, a final option I wanted to mention is the B1, B2 visa, which you'll see listed at the bottom of our slide there. Now, this is really a non-immigrant visa option, but I broke it out because individuals do not need an employer sponsor to use the B1 or the B2. The B1 visa is used for short visits to the U.S. for business, and the B2 is used for short visits for pleasure, like tourism. The period of stay on the B1, B2 visa is limited to 180 days, but in some cases, one could stay for up to 1 year. The Visa Waiver Program, or what many of you may know as ESTA, allows citizens of certain countries to travel to the U.S. For business or pleasure without actually having to obtain a B1, B2 visa in their passports. But the trade-off there is if one uses the Visa Waiver Program, their period of stay is limited to 90 days. Also, ESTA registration is required online prior to visa program travel, and the registration is valid for 2 years. So it's really important to note that the B1 business visitor category has limited use by employers because it does not permit work in the U.S. This means that business visitors cannot perform services for a U.S. employer to benefit its U.S. business. Some of the activities that business visitors can engage in include attending seminars and conferences, meeting with colleagues or U.S.-based team members, meeting with clients and developing new business, meeting with third parties like attorneys and accountants, or coming to a U.S. worksite to gather data. It's also important to note that business visitors may not receive remuneration or payment from a U.S. source, so they cannot be on U.S. payroll. Notably, however, incidental expenses like travel expenses can be paid by a U.S. source. So, for example, if you're flying an overseas employee to the U.S. to engage in on-site research and meetings, the U.S. company can pay for her travel expenses. Those are considered incidental expenses. In addition, a B1 visitor can, in certain limited circumstances, accept honorarium payment from a U.S. source. And this would be for academic activities that last no longer than 9 days and that meet a list of other requirements. And these activities include lecturing or guest teaching. So, because of the limited nature of the B1, B2 visa, it's recommended that these travelers be in possession of a round-trip ticket to show their intent to remain in the U.S. temporarily and to return home after a set period of time. It's also recommended that they be in possession of proof of foreign employment, including proof that they will be compensated on a foreign payroll by an overseas employer while they're in the U.S. So the non-immigrant visa categories which actually permit employment in the U.S. require much more extensive analysis and documentation than the B1 business visitor. And now Surabhi and Aisling are going to talk us through some of those non-immigrant visa options. To introduce their discussion, I'm going to read us a few hypos, which you'll see on our next slide. Okay, so let's say your international company has recently launched a new line of nutritional supplements that is doing very well in the U.S. market. It now wishes to expand its U.S. research and development facilities to further develop this product line. There are 2 open positions at this new facility, one for a senior scientist and the other for a junior scientist. And you're considering the following candidates. For your senior scientist, you'd like to hire Dr. Angela Taylor. She's a biochemist with an accomplished resume in food and nutrition science. She's a dual Canadian-UK citizen and received a PhD in biochemistry from Oxford. She has performed biochemistry research for 15 years, has published over 30 biochemistry studies in the area of food and nutrition science in international peer-reviewed journals, and currently serves as a lab director for your company in the United Kingdom. Additionally, from May 2012 to May 2013, just prior to joining your company in the UK, she completed a very prestigious 1-year fellowship in J1 status in the US. For your junior scientist, you're looking at Mr. Jack Carlin. He's an Irish citizen who received a bachelor's degree in microbiology here in the U.S. at NYU. He has 3 years of work experience with a large U.S. pharmaceutical company in the area of fermentation science and currently holds H-1B status. So Survi, would you please talk us through some of the temporary work visa options that are available to Angela and Jack?
Yes, thanks, Phil. I think the best way to get started on digesting the alphabet soup of non-immigrant visa options that you mentioned before is to summarize options for Angela and Jack, and then to take an in-depth review of both of their options by visa category. So let's start with Angela. By virtue of her high academic and professional credentials and her nationality, Angela has several visa options available to her, namely the H-1B visa, the O-1 visa, the L-1 visa, the TN visa, and possibly even the J-1 and E-2 visa. So it seems like she's in pretty good shape. In contrast, because of Jack's nationality, lower level of academic study, and lesser professional credentials, Jack's visa options are limited to an H-1B visa and possibly an E-2 or J-1 visa. I'll discuss the H-1, O-1, and J-1 visa options, and then I'll hand it over to my colleague Aisling, who will discuss the TN, L-1, and E-2 visa options. So let's start with the H-1B. It is the most popular working visa in the U.S. It's typically granted in 3-year increments for a total of up to 6 years, though it is possible to become eligible for a new 6-year allotment by exiting the U.S. for 1 continuous year. In addition, there are certain exceptions that allow foreign nationals to extend their H-1B status past 6 years, which we'll discuss a bit later. And importantly, I want to note that the employer sponsoring the H-1B visa must pay for all legal and government fees associated with its filing. So how would you know if Angela or Jack are eligible for the H-1B visa? Well, there's a 4-part test to determine eligibility, and I'm going to go through it now. First, there must be a job offer from a company located in the U.S. In our hypothetical, this is the case for Angela and Jack with their offered employment with your company. Second, the job must require at least a bachelor's degree related to the job. Going back to our hypothetical, we can assume that both the senior scientist and junior scientist positions require at least a bachelor's degree in biology or chemistry or a related field. Third, the prospective employee must have at least a U.S. bachelor's degree or a foreign degree equivalent, or the experiential equivalent of a U.S. bachelor's degree related to the job. So in our hypothetical, Jack's microbiology degree was earned in the U.S., so he meets this requirement. But Angela, she received her degree from abroad, so we'd have to have it evaluated by a degree evaluation service to be sure her PhD is at least the equivalent to a U.S. bachelor's degree, and I think it would be. And last, the job must offer a salary that meets a certain government minimum for the profession in the geographic area of employment. This minimum compensation is called a prevailing wage. For this, we need to review the offered salary for both the senior and junior scientist positions, and then check them against the Department of Labor's wage surveys in the geographic area of employment for these positions to see if Angela and Jack are being offered the prevailing wage. In addition, even if they are being offered the prevailing wage, their offered wage must also be equal to or higher than other similar workers at the same company worksite with similar experience and qualifications. So let's go back to our hypothetical. We learned that Jack currently holds H-1B status. Assuming that Jack is offered the appropriate wage by your company can file an H-1B transfer petition for Jack, but only if Jack has H-1B time left. Just as a reminder, Jack can have H-1B status for only up to 6 years. And while this does not apply to Jack, I also want to point out that any time spent in the U.S. in L1 status counts towards the 6-year H-1B allotment. Now let's turn back to Angela. Assuming that Angela's foreign PhD is evaluated to be the equivalent of at least a related U.S. bachelor's degree, and assuming Angela is offered the appropriate wage, it then appears she's eligible for an H-1B visa. Unfortunately, even if she is eligible, it doesn't mean that she'll get one or that it will meet your company's hiring needs in terms of a start date. And this is because there's only a certain number of new H-1B visas available every year, and they can only be eligible for use at a certain time of the year. So specifically, Congress has designated 65,000 H-1B visas each year for those with a U.S. bachelor's degree or its equivalent, and an additional 20,000 are available for those who have received a master's degree or higher in the U.S. These limited H-1Bs are called CAP subject H-1Bs, and they are only available for use starting October 1st of each year. And employers can only file applications up to 6 months in advance of October 1st, which brings us to April 1st of every year. There is currently a really high demand for H-1B visas, and just last year, about twice as many H-1B applications were filed on April 1st than there were available visas, and this often happens when the economy starts to get stronger. When this happens, the government uses a lottery system to choose which applications get processed. So let's go back to our hypothetical again. It is October 22nd, 2014, and you need to fill the senior scientist position immediately, and you want to file an H-1B petition for Angela. As we just discussed, all the H-1B visas for an October 1st start date of this year were already handed out back in April. So this means the next time you can file an H-1B petition for Angela would be April 1st of 2015 for an October 1st, 2015 start date. This is nearly a year away, and this scenario is a very real problem that many employers face when considering the H-1B visa. It's just too far off. Fortunately for Angela, she has a lot of other visa options, but not everyone does. So our other candidate, Jack, doesn't have to face these issues. He already has H-1B status and managed these H-1B CAP issues when he first received his visa. He doesn't have to manage these issues again when applying to transfer employers or to extend his status.
Okay, great, Survi. So you just mentioned a really important issue with H-1B visas, that the supply is limited by Congress. Are there any exceptions to this?
Yeah, that brings us to our next slide. There is a class of H-1B visas called CAP-exempt H-1Bs, and they are available in unlimited quantity and for use at any time of the year. The CAP does not apply to H-1B filings for institutions of higher education, like colleges and universities, to nonprofit research organizations, to government research organizations, and to nonprofit entities that are affiliated with institutions of higher education. And even within these exceptions, there are some additional loopholes that are worth mentioning. So for instance, in our example, you are a for-profit employer. If you plan to employ Angela in H-1B status, and she will physically conduct the majority of her work at a CAP-exempt institution of higher education, so such as a university research partner, or at a nonprofit that's affiliated with an institution of higher education, such as a teaching hospital, then this employment will be granted as CAP-exempt, so long as there is a logical nexus between Angela's work and the normal, primary, or essential work performed by the institution of higher education or the nonprofit that's affiliated. Now let's go back to Jack for a couple more important points. I mentioned earlier that since he already has an H-1B visa, he is not subject to the H-1B cap when transferring employment. This is actually only true if his last H-1B petition was subject to the cap. If he was never subject to the cap before, and he's now seeking to move to a cap subject position, he's going to face the same limitations as Angela in terms of fighting for one of those limited number of cap subject H-1B visas, and in terms of having to manage an October 1st start date. I do want to clear it out there, though, that there is some guidance that suggests there is a way to bridge the gap between cap-exempt employment and the start date of a cap subject visa before October 1st, but only in limited circumstances. It's also important to remember that any time already spent in cap-exempt H-1B status still counts against the 6-year maximum allotment for H-1Bs. And let's go back to our hypothetical for one last cap exemption loophole. Let's assume Jack's current H-1B position is cap exempt, and the position you're offering him is cap subject, and Jack wants to work at both jobs simultaneously. As long as he is maintaining his cap exempt employment and H-1B status, then he can begin with your company after you file a concurrent H-1B petition, and the government will approve it as cap exempt.
Thanks, Survi. That's really interesting. I'm thinking here to myself, in terms of other loopholes to the H-1B cap, would a foreign national's country of citizenship provide any advantage?
It does, but only in limited circumstances. There are some other visa categories very similar to the H-1B that also have quotas and require meeting the wage requirements we discussed earlier, and this applies to the H-1B1 visa for Chilean and Singaporean nationals, and the E-3 visa for Australian nationals.
Great. So the advantage that those quotas present are that they are not in as high demand as the regular H-1B caps. Is that correct?
That's correct.
Okay, great. All right, so why don't we change Jack's scenario slightly for a moment? What if Jack held an H-1B visa for 3 years? It was subject to the cap, then went back to school in the U.S. for a master's degree in microbiology and is now about to graduate and has applied for the junior scientist position. What visa options are available to him now?
Well, we need to take a look at his current status to see, to best analyze his options. So he's a student, and foreign students typically enroll in U.S. colleges and universities in F1 student status. At the end of a U.S. degree program, these students are granted 1 year of work authorization. This period is called optional practical training, or you might hear it as OPT for short. Students with this OPT period are given a work card, and students in all fields who've completed a bachelor's degree or higher in the U.S. are eligible for this 1 year work card. Now, during this 1 year period, Jack can work with any employer and even be self-employed, so long as the work is related to his field of study. For him to assume the junior scientist position, Jack would need to show you his work card to prove his eligibility to work. This work card is a huge benefit for employers as it doesn't require you to sponsor any visa. In addition, students like Jack who've earned a U.S. degree in science, technology, engineering, or math, or what we call STEM degrees, are eligible for an additional 17-month extension of this work card, but only if their employer is enrolled in a government program called E-Verify. Thus, it would be beneficial as an employer to enroll in E-Verify in terms of being able to keep Jack employed using his work card for a total of 29 months rather than just 12 months. At the end of the OPT period, you may wish to continue employing Jack, and you'll need to explore other visa options. As we mentioned before, the most common option employers explore is the H-1B visa. Since Jack held an H-1B visa just before he went back to school, he may not have to face a cap subject H-1B application if his last petition was cap subject. In that case, you could assume employment with your company in H-1B status once you file a petition for him, but again, he will only be granted up to 6 years in H-1B status, including the 3 years time he held before he went to school. Now, if his prior H-1B petition was cap exempt and your offered position is cap subject, then he'll face the same issues again of having to fight for one of the limited number of H-1B cap subject visas. However, he may not have to face the issue of how to bridge the gap between a work card end date and an October 1st H-1B start date, depending on when his work card expires, and this is because there's special government provisions for F1 students changing to H-1B status. You might hear this referred to as cap gap provisions. And I want to mention as a practice pointer, if you do hire an employee using their 1 year OPT work card, you normally only have one chance to apply for a cap subject H-1B petition on his or her behalf. But in Jack's case, as a STEM graduate who can extend his work card for up to 29 months, you have two chances over a course of 2 years to apply for a cap subject H-1B on his behalf.
Okay, that's great. So had Jack just completed his studies, OPT would have been a great option for him and a very flexible one for the company, especially because he's in a STEM field. But since he has not just completed his studies, could you please discuss a possible J-1 option for him as well as for Angela?
Sure. So the J-1 visa is a broad visa that allows some professionals to work in the U.S. while allowing others to come to the U.S. to receive training or complete an internship. And for J's, there's typically three parties involved: a program sponsor, a foreign national, and a host employer. In terms of the mechanics, the program sponsor is approved by the U.S. Department of State to certify a foreign national to participate in the J-1 program with a host employer. And sometimes you'll see that the host employer and the program sponsor are the same entity. And unlike the H-1B visa, there is no visa quota or cap for J-1. There's no prevailing wage obligation, and there's no restriction on which party can pay for the program fees or associated legal fees. But J-1 program sponsors will often seek assurance that foreign nationals intend to return to their home country at the end of a J-1 program. And this is because the primary purpose of a J-1 program is for foreign nationals to learn professional skills and learn about American culture, and then share this knowledge in their home country. And in fact, J-1 visas are called exchange visitor visas for this purpose. So let's discuss some specific J1 categories that apply to scientists. The first category is a 12-month J1 intern, and for this, a foreign national must be currently enrolled in a foreign college to pursue a degree or professional certificate, or show that he or she has graduated from such a foreign college no more than 1 year prior to the beginning of the J1 intern program. The second category is an 18-month J1 trainee, and for this, a foreign national must have a foreign college degree or professional certificate and 1 year of related work experience, or in the alternative, he or she must have 5 years of work experience in the field for which he or she is seeking additional training. And the J1 intern and trainee programs are really programs that are for learning and not a regular full-time job. The third and fourth categories are J1 short-term scholars and J1 research scholars. These scholars are required to primarily conduct, observe, or consult on research in academia or the government, and most program sponsors will require a showing of at least a bachelor's degree or higher, regardless where in the world the degree was granted. Short-term scholar visas are in fact short and are granted for just 6 months, whereas research scholar visas can be granted for up to 5 years. And the fifth category is a J1 professor, which is, as it sounds, for teaching. It can also be granted for up to 5 years. So let's go back to our example. Angela previously held J1 status for 1 year. Given the 1 year duration of her program and her high level of professional accomplishment, it's likely that Angela was here as either a J1 research scholar or professor and not in one of the learning programs of intern or trainee, and because she was here for 1 year, she couldn't have been here as a short-term scholar. It's worth noting that because Angela completed a research scholar or professor program, she's not eligible to complete another one for 2 years after the end of her last program. In Angela's case, if she's not able to obtain an H-1B visa to work with your company, but is instead offered a temporary scientist position to conduct research, and that position would naturally term within 5 years, she would be eligible for a J1 research scholar visa, but only after 2 years have passed since she completed her J1 program. Let's also not forget about Jack. If he's being offered a temporary research position that will naturally terminate within 5 years, he may also be eligible for a J1 research scholar visa. Even though he's newer to the field, he wouldn't be eligible for the J1 intern and trainee visas, as the junior scientist position doesn't appear to be a training or internship program, and also because he does not meet the foreign degree or experience requirement. I want to mention one more thing about J1s, which is fairly important, and that it may require a foreign national to return to his or her home country for a period of 2 years before he or she can pursue certain other visas, like the H-1B visa, the L-1 visa, and even the green card. Whether foreign nationals are subject to this 2-year home residency requirement will depend on their home country, whether the J1 program involved government funding, and the type of skills the foreign national gained through the J1 program. So going back to when we determined Angela was eligible for an H-1B visa, we would actually need to check if her prior J1 status required her to return home for 2 years before she could apply for an H-1B visa. If she is subject to this requirement, then she will have to meet the 2-year home residency requirement or obtain a waiver of the requirement before applying for an H-1B visa.
Okay, Survi, so it seems like the J1 is really not appropriate for someone with Angela's career level and J1 immigration history, but could possibly work for Jack under the research scholar category. Let's assume that ultimately the J1 is not viable for Jack, possibly because he does not have the temporary intent that's required for the J1 category. Would an O1 visa be a viable alternative for him or Angela?
I think it would be for Angela and not for Jack. So let's go through the details of that visa. An O1 visa is for those who have sustained national or international claim in the arts, business, science, or athletics. And like the H-1B visa, the O1 visa requires sponsorship from an employer in the U.S., and it is normally granted in 3-year increments. But there are some key differences from the H-1B visa. There's no visa quota or cap. There's no prevailing wage obligation. There's no restriction on which party can pay for legal and filing fees. And there's no cap on how many years one can hold O1 status, though that's subject to temporary intent. In exchange for these leniencies, the O1 visa requires a high level of professional accomplishment. So for professionals in the sciences, the government looks to see if the foreign national has won a major internationally recognized award, like the Nobel Prize. But fear not. Even if a foreign national doesn't have such an award, like most professionals, The government instead looks to see if the foreign national can meet at least 3 of 8 lesser criteria. So what does this look like for scientists? This looks like if the foreign national has published work in reputable journals, has any press on him or herself, has made major contributions to his or her field, has held leading or critical roles at distinguished institutions, has judged the work of his or her peers, i.e., done peer review for journals or manuscript editing, holds selective professional memberships, has won industry awards or prizes, and has or will command a high salary compared to his or her peers. So let's go back to our hypothetical again. Angela has published work in reputable journals. She's made major contributions to her field. She's held leadership roles with distinguished institutions like yours abroad, and she likely commands a high salary. For these reasons, she would meet at least 3 of the 8 O1 criteria and be eligible for an O1 visa. And finally, I think we can all agree that our friend Jack, given his lesser years of experience in the field, does not have sustained national or international acclaim and likely cannot meet 3 of the 8 O1 criteria, and thus the O1 is not available to him at this stage in his career.
Okay, Survi, so we know that Angela previously held J1 status and that some J1 visa holders are subject to the 2-year home residency requirement. Would the O1 visa still be an option for Angela if it turns out that she's subject to the J1 2-year home residency requirement?
That's a good question, and the answer is yes. If Angela is subject to the 2-year home residency requirement and has not met it or received a waiver, she's only prohibited from applying to specific visa categories, namely the H, L, and K visas and the green card, but she's absolutely free to apply for the O1 visa and other visa categories that we didn't just list.
Great. Thank you so much, Survi. Based on your discussion, it appears that the O1 would likely be a viable route for Angela and the H1B for Jack. But there are a couple more visa options which may work, particularly for Angela. So, Ashley, how about the TN and L1 visas?
Okay, thank you, Phil. Well, yes, since Angela is a dual Canadian citizen, it certainly would make sense to explore the TN option for her. Unfortunately, as an Irish citizen, Jack would not have the option to apply for a TN because, of course, he would need to be a Canadian or Mexican citizen to qualify. So, as many of you know, the North America Free Trade Agreement, or NAFTA as it's known, created special economic and trade relationships between the United States, Canada and Mexico, and with it, the TN non-immigrant classification permits qualified Canadian and Mexican citizens to seek temporary entry into the United States to engage in certain business activities at a professional level. So to be eligible for TN status, the foreign national must demonstrate at least a baccalaureate degree or appropriate credentials demonstrating their status as a professional in one of the occupational categories set out in the NAFTA appendix. If required by state or local laws, the foreign national must also comply with all applicable laws and licensing requirements for the professional activity. The NAFTA appendix for professionals includes many science classifications, luckily, and these are set out in the next slide, and we're going to take a look at these for Angela in just a moment. First, I just want to provide a bit more information on the TN. So, as I mentioned, it's a status available only to Canadian and Mexican citizens and can be sought for a validity period of up to 3 years initially. It is renewable in 3-year increments, and in theory at least, it is renewable indefinitely. In contrast to the H1B, there is no cap or quota, and there is no prevailing wage obligation. However, I should say that wages should generally be commensurate with that of a professional in the relevant occupation. Phil mentioned temporary intent at the outset of our discussion. TN professionals are subject to temporary intent. In other words, the foreign national must prove that they have no intention to immigrate to the United States, but instead they need to be coming temporarily to perform their business activities and then return home. This doesn't actually rule out green card sponsorship for an employee in TN status, but it does require some careful strategizing if an employer decides to proceed with an immigrant visa case.
Okay, Aisling, if I could just interrupt you here for a quick question. How would an employer go about actually securing TN status for its employee?
So the mechanics of applying for TN status depend on whether a person is Canadian or Mexican. And actually, neither is required to file a petition with USCIS in advance, which is the case with other classifications such as H-1Bs. Mexican citizens can apply for a TN visa directly at a US consulate abroad. For the TN visa application, they would simply present a letter of support from the employer, which confirms the professional nature of the position, the employee's educational credentials, which would mirror those listed in the NAFTA appendix, and also the salary and terms of employment. The consular officer then grants the TN visa for admission to the United States. And Canadians have actually two filing options when coming to the United States in TN status. Because Canadians are visa exempt, they have the option to apply for TN status directly at the US border. So in this scenario, the immigration officer adjudicates the TN application when the person applies to enter the United States. The Canadian employee would bring the same type of letter of support from the employer, which confirms the US position, the educational credentials, and the salary and terms of employment. A big advantage to making the application at the Canadian border is that it is cost effective and quick. For example, the border filing fee is just $56. However, you should be aware that border officers have quite a bit of discretion in adjudicating TN applications, and they can also become confused and wary of non-traditional job descriptions that don't neatly fit within the NAFTA appendix. In general, there is a lack of consistency with border applications, and except in very straightforward cases, sometimes employers just prefer not to send new employees to the border to request admission in TN status, and instead they would opt to file at the service centre, which is the second option. But just for a Canadian border application, I just wanted to mention that for Angela travelling from the UK, she would need to fly through Canada to apply for the TN at the border. So that's just something to bear in mind for her. So as I mentioned, in the alternative, her employer could choose the second TN filing option for Canadians, which is to file the petition at a US service centre in advance. And then once the petition is approved, the employee can take the approval notice to any US port of entry for admission in TN status. So in this scenario, as I mentioned, Angela could fly directly from London to JFK or any other airport in the US and then seek admission in TN status using the approval notice from the service centre. Generally speaking, employers can choose the service centre option for a variety of reasons. Perhaps the job is unusual, as I mentioned, and does not fit the traditional occupational classification in the NAFTA, or because the foreign national has had a bad experience at the border previously, or indeed because the foreign national is already in the United States working for another employer in TN status, and they don't wish to travel to the border to apply for the TN. If you're filing at the service centre, just to note that the TN petition can be filed by premium processing for a decision within 15 days. So returning to Angela, let's take a look at the NAFTA appendix on the next slide. As I mentioned, the NAFTA appendix contains many science classifications, and you'll see there in that list that the category of biochemist appears on the slide. So obviously with her degree in biochemistry and a job offer as a senior scientist in this field, the TN could be very viable and cost effective for Angela. It's worth noting that even if a scientist's functional job title will be quite different from what's listed on the NAFTA appendix, it might still be possible to classify that individual as a NAFTA scientist as long as the position requires those specific scientific credentials for the successful completion of the job duties. So for example, if the position title is product manager or something like that, and it sounds a bit more like a sales and marketing role, it may still be possible to qualify that employee as a biochemist, as long as the job requires the principles and skills gained in that undergraduate degree in biochemistry to perform the job duties. So in that respect, it's quite important to drill down to the credentials and see whether the degree will be leveraged in the US position. I just wanted to mention as well, as a side note, it is acceptable that Angela's credentials are from Oxford University in the UK. They're not Canadian or Mexican or US credentials, but they would just need to be evaluated to show equivalency to the requirements listed in the NAFTA appendix.
Okay, great, Aisling. So at the moment, the company is considering Angela for a senior scientist position, which seems to correspond to the biochemist category under NAFTA. What if she is promoted to a more senior managerial role within the organization after she transfers to the U.S.? Would this promotion be okay from a TN perspective?
So, well, actually, Phil, the NAFTA does not really contemplate management roles. There is a management consultant category, which we'll talk about in a moment, and it's not really, in fact, a good fit for most managers. So there's really no facility to transfer managers under the NAFTA. So it would be important to show that as a senior scientist, Angela will actually be performing duties as a biochemist, and she won't be merely overseeing the lab or engaging in purely managerial activities.
That's really interesting. Thanks for that. I have another question on mechanics. You mentioned a TN change of employer scenario. Could you please explain how that actually plays out? Specifically, if an employee is working for a company in the U.S. in TN status, and they are offered TN employment with a different company in the U.S., can that person begin work with the second company once the TN petition is filed on their behalf?
Okay, so while it is permissible for an employer to file a change of employer TN petition for a foreign national while they're in the United States, there is no portability for TNs like there is in the H-1B context. So just to explain, for H-1B change of employer petitions, it's possible for the employee to commence work with the new employer as early as the receipt date of the H-1B petition. However, for TNs, the employee needs to wait for the actual approval notice before they can commence work. Since there is a 15-day premium processing facility, the employer can expedite the process. However, it is an expensive solution. Of course, a new employee, even if already working in the United States for another employer in TN status, can opt to make a new TN application at the border or go back to the consulate in Mexico if they're willing to make that trip.
Okay. And I have one final question on TNs. Are there any other NAFTA categories that might accommodate science or research positions?
So yes, we have included some other NAFTA categories that could potentially be used to employ TN scientists. These are in the next slide here. These include medical and allied professions, engineers, and also scientific technician or technologist. With respect to the medical and allied professions, I just want to note the occupation of nutritionist appears there. Angela has focused her research studies in the area of food and nutrition, so it could be tempting to seek to use that category for her TN. However, given her credentials and the fact that she won't be performing a role primarily advising on nutrition, it looks like the biochemist category would be a better fit for her. We've also included the category of management consultant in the slide. This isn't actually because it's a particularly useful category for scientists, but employers often ask us whether it's a viable option for scientists if there's no other appropriate category in the NAFTA appendix. We're really including it today to make the point that it's quite a tricky TN classification which faces scrutiny by USCIS and border officers. It's one of the few NAFTA categories that does not specifically require a degree. Instead, the foreign national can have 5 years of experience in consulting or 5 years of experience in a field of specialty related to the consulting agreement. So in reality, this category suits only a very small pool of potential transferees. And also, very importantly, management consultants are usually independent contractors or employees of consulting firms under contracts to U.S. entities. So just to sum up the TN, it could be a viable option for Angela. However, it's really only a temporary option, and the company would need to be mindful of the logistics of her applying for the TN either at the border or at the service centre in advance. So I just also want to take a quick look at the L1 option for Angela. Once again, Jack will not be able to avail of the L1 option for reasons I'll explain in a moment. In general, the L1 classification enables a U.S. employer to transfer executives, managers, or specialized knowledge workers from one of its affiliated foreign offices to one of its offices in the U.S. on a temporary basis. The U.S. petitioner must have a qualifying relationship with a foreign company. That is, it must be a parent, affiliate, subsidiary, branch office, or joint venture. The transferee must have worked for the qualifying organisation abroad for at least one full continuous year within the 3 years prior to the transfer. In contrast to the H-1B, there is no quota or cap for the L1, no prevailing wage obligation, although again salaries should be commensurate with the managerial or professional nature of the position. For L1s, the employee can actually remain on home country payroll, so that's a nice point to bear in mind. So Angela has been employed for at least 1 year with an affiliate abroad, so this could be a good option for her, assuming she meets other eligibility criteria. Jack does not have 1 year of employment with a qualifying entity though, so he would not be able to avail of the L1 option. Just want to make the point there are two separate L1 classifications. The L1A is for executives and managers and can be sought for an initial 3-year period, renewable in 2-year increments with a maximum period of stay of up to 7 years. The L1B is for employees who possess specialized knowledge and can be sought for an initial 3-year period, renewable up to 5 years in the US. So the definitions of executive, manager and specialized knowledge are set out in government regulations, and I just want to touch upon these briefly today because I do think it's useful. So generally, as you can imagine, an executive is an employee who operates at a very senior level in the organization, directing the management of the organization or a major component of the organization. And they only receive general supervision and direction from more senior executives, boards of directors, shareholders. So we don't typically come across executives, on a day-to-day basis, really. But a manager is something that we do consider often, and they are defined as an employee who manages the organization or a department or function of the organization. The manager exercises discretion over the day-to-day operations of the organization or a department or function within the organization. And the immigration agencies actually recognize two types of managers, including the traditional staff manager who supervises and controls the work of other personnel and has authority over personnel actions, hiring and firing, that kind of thing. And then the second type is functional managers, or those who manage an essential function of the business and operate at a senior level with respect to that function. With functional managers, these folks don't have to have a team of direct reports under their authority, but it's very important that the employee is not shown to be executing any of the actual tasks associated with the function. So other professionals should be doing the actual work. So for example, if an L1A employee is a senior scientist in charge of product development, he or she should primarily direct the function and its budget, define the strategy, set the goals and policies for the function. However, other professionals must be responsible for executing the actual research, performing the sales and marketing tasks, and all of those associated tasks with the function. So as you can imagine, it can be quite difficult to describe a functional manager. Finally, I just want to touch on a specialized knowledge employee. This is a professional with special knowledge of the organization's product, service, research, equipment, techniques, management, or other interests. And it can also be a professional with an advanced level of knowledge or expertise in the organization's processes and procedures. So if Angela is being offered a position which involves either staff or functional management, she could be eligible for an L1A transfer. It's also likely that she has special knowledge of your company's product, services, research and techniques, which she will be applying in the US role. Therefore, she could also qualify for L1B status. If she's transferring as a manager, she would not need to have held the same exact managerial experience abroad as in the US role to qualify. It's also possible to qualify for an L1A manager transfer on the basis of specialized knowledge gained overseas. So that's something to bear in mind. So in a situation like this, where the employee could qualify for either the L1A or the L1B, employers usually opt to transfer the foreign national as a manager because of the 7-year maximum period of stay for L1As versus the 5-year maximum period of stay for specialized knowledge workers. And then I just want to mention, in addition, where both the foreign national and the US roles are both managerial, there is a fast-track route to a green card, which Phil's going to just talk about briefly in a moment. I also just want to briefly mention the L1 blanket option that many of you may have heard of. So for large companies that meet substantial revenue and operational requirements, it's possible to petition to USCIS for an L1 blanket, which is effectively pre-approval of the qualifying relationship between related entities. And the L1 blanket makes it pretty convenient actually for global companies to transfer its qualifying L1 employees to the US. It allows an employee to go directly to a US consulate abroad to apply for an L1 visa, as long as their overseas employer and the prospective US employer both appear on the blanket. Otherwise, a petition needs to be filed with the US Citizenship and Immigration Service in the US. So again, if Angela's employing company has an approved L1 blanket, it could be used as a really cost-effective means to transfer her to the US.
Okay, Ashley, so folks listening in may be thinking that the L1 visa sounds a bit like another category known as the E2. Could you briefly explain what the E2 category is and whether it would work here?
Sure, Phil, yeah. The E2 is somewhat similar to the L1. The E2 is it's for employees of foreign treaty investor companies operating in the US who wish to transfer executives, managers, and essential skills personnel to the US. In contrast to the L1, E2 transferring employees must hold the same nationality as the investor company. So if the company is a British company, it can only transfer employees in E2 status if they have UK citizenship. Also, in contrast to the L1, for the E2, there is no requirement that the transferring employees have worked abroad with a qualifying organisation for any period of time prior to the transfer. E2 employees can also make visa applications directly to the US consulate abroad once the E2 company has registered with the consulate by providing substantial evidence of its business operations, its US investment, and its nationality. So Jack would not be eligible for an L1 transfer because he doesn't have the 1-year qualifying period abroad. But if the US employer had the same nationality as him and was an E2 registered company, in other words, if it was an Irish E2 company, and if Jack had essential skills required to perform the professional duties, he could be E2 eligible. The same would apply to Angela if the US employer were a British or Canadian E2 registered company.
Okay, great. I have another question, Ashley. Would Angela's prior J1 affect her application for the L1 visa?
Right. So since Angela has already held J1 status in the US as a research scholar, yes, it would be important to ensure that she has a full year of continuous employment with the qualifying entity abroad before she can apply for the L1 visa. If she doesn't, she would just need to remain in the role abroad until she has gained the requisite qualifying experience. In addition, her J1 documentation would need to be reviewed carefully to ensure that she was not subject to the 2-year home residency rule, which Survey has mentioned. This could have been imposed on Angela, for example, if she were provided with any government funding from either a US or another government source. In that case, she would not be able to apply for an L1 visa until she has remained in her home country for 2 years or until she received a waiver of the requirement. Just to make the point that she would be able to apply for a TN without satisfying the 2-year home rule requirement.
Okay, very interesting. So the L1 sounds like a viable option for Angela as long as she's not subject to or can overcome the J1 2-year home return requirement. Are there any other more general issues to be mindful of with L1 visas?
Well, unfortunately, the L1 is not without its challenges. Certainly in the current climate, there is skepticism within the immigration agencies about whether employees are truly managerial. And there's no doubt that a functional manager case is harder to prove than a staff manager case. For L1Bs, there's also a very narrow interpretation of what specialised knowledge really is. Oftentimes, adjudicators just go beyond the definition of specialised knowledge that's set out in the regulations and impose their own much more restrictive interpretation of specialised knowledge. Also, even though the qualifying period of experience is just 1 year according to the regulations, the agencies tend to take the view that 1 year of employment overseas is not enough time to acquire specialised knowledge. Instead, they want to see a history of employment with the company, including evidence of formal and on-the-job training. So in general, L1 employers are seeing an increase in requests for evidence from USCIS, an increase in consular denials, and also an increase in site visits by the US government agencies.
Okay, thanks very much, Aisling. And now I think what we'll do is switch gears and talk for about 15 minutes about the ways that scientists and researchers can achieve permanent resident status in the U.S., or what's commonly known as the green card. Okay, so the employer-sponsored green card process, as you'll see on our slide, is either composed of 2 or 3 steps. I'm going to discuss these steps in detail in a moment, but just as a general introduction, in the 3-step process, the first step is called the PERM Labor Certification Application, and this is filed with the U.S. Department of Labor and requires an extensive recruitment effort to demonstrate a shortage of qualified U.S. workers to fill the foreign employees role. Step 2 of the process is called the I-140 petition, and this is filed with Immigration, USCIS. In some circumstances, the green card process will actually be exempt from the PERM labor certification and can proceed directly to the I-140 petition. Many times, scientists and researchers fall within these very desirable exemptions if they can show that they're a multinational manager or executive, an alien of extraordinary ability, an alien whose immigration would be within the U.S. national interest, or an outstanding researcher. And again, I will discuss each of these exemptions in more detail in just a minute. Turning back to our slide, step 3 of the green card process is called the immigrant visa application, and this can be filed in one of 2 ways. Either as an adjustment of status application to USCIS in the United States, or via a consular application made to a U.S. consular post overseas. It's really important to note that an individual is not eligible to submit step 3 until his or her priority date becomes current under the Visa Bulletin, which is found on the Department of State's website. So on our next slide, we've provided a sample Visa Bulletin to help you understand the concept of priority dates becoming current. As you can see in the sample Visa Bulletin, employment-based green cards are issued via a system which allots limited numbers of green cards to applicants according to their country of birth and the employment-based category in which their green card application falls. So the country of birth is listed along the top row, shaded in dark gray, and the employment-based category is listed along the left-hand column. These categories are listed as first, second, third, and so forth, and many of you may have heard these referred to as EB1, EB2, and EB3. These are the most popular employment-based green card categories for scientists and researchers, and each are backlogged according to demand. PERM-based green card applications will fall within the EB2 or EB3 categories, while some of the PERM-exempt applications, such as multinational manager and extraordinary ability, fall under EB1. Now, an individual's priority date, going back to priority dates, is established by PERM filing date, or if the PERM is not required, by the I-140 filing date. To check whether the priority date is current under the Visa Bulletin, the individual would have to locate the most recent Visa Bulletin online. They're issued once each month, and locate his or her green card categories such as EB1, EB2, or EB3, and then review the listed cutoff date under his or her country of birth. Once the priority date reaches or surpasses the cutoff date, it will be considered current, and the individual will then become eligible to file step 3 of the green card process. So as long as the priority date is backlogged, the individual has to wait to file step 3. And so if you take a look at some of the cutoff dates on the chart here, you'll see that there are substantial wait times for individuals born in China and India in the EB2 and EB3 categories. On the other hand, some categories, mostly EB1, list a C under certain or all countries. And this is great and means that the category is current. In that case, there would be no backlogs. The priority date would be current, and the individual could proceed to step 3 of the green card process without having to wait. So hopefully now we understand the basic framework for green card applications. So what I want to do is just take a step back and look at the specific green card steps in a little bit more detail. The first application process I'd like to discuss is the PERM labor certification. So PERM. So what does it stand for? Program Electronic Review Management. And it's an attestation and audit-based electronic application involving a recruitment campaign as well as extensive record maintenance obligations by the employer. Essentially, it requires an application to the Department of Labor to obtain certification that there are no qualified, willing, and available U.S. workers in the area of intended employment to fill the position offered to the foreign worker you are sponsoring. So this is envisioned to be a protection that the government has put in place for U.S. workers. The period of recruitment is meant to test the U.S. labor market in the geographic area of the job held by the foreign worker, and it involves placing a series of legally mandated ads like Sunday newspaper ads and ads online, and reviewing job applications for a period of at least 60 days. It's important to note that since the economic downturn in 2008, the Department of Labor has really scrutinized PERM applications more heavily, and they've done so by increasing their audits. The primary issue that the Department of Labor is probing in an audit is recruitment, to ensure that employers have lawfully tested the labor market and that there were indeed no qualified, willing, and available U.S. workers. This increase in audits means that employers need to work with counsel extra vigilantly to document PERM recruitment campaigns and as well as the reasons for rejecting each applicant. Now, during an audit scenario, even though DOL is focusing on recruitment, in theory they can question any one of the attestations that an employer makes when it files a PERM application. So here, I think it's important to quickly review some of those key attestations. First, when an employer files a PERM, it attests that the advertisement for the position lists the actual minimum academic and experiential requirements for the job. Now, this attestation is particularly strategic as it determines whether the application gets classified within the EB2 or EB3 category. A case is EB2 when the PERM job's minimum requirements are at least an advanced degree, which is defined as a master's degree or higher, or a bachelor's degree and at least 5 years of post-baccalaureate experience. A case is EB3 when the minimum requirements for the job are at least a bachelor's degree or 2 years of work experience. Now, many of you have probably had your foreign employees ask you if their application could be EB2. And the reason they so frantically want EB2 is quite understandable. EB2 is less backlogged than EB3. The processing is quicker. And many times these foreign workers will note, I want to be EB2 because I have a master's degree. Well, it's really important to note that the category of EB2 is not determined by what education credentials the foreign worker possesses. Though the foreign worker does have to possess the minimum requirements, the actual category is not determined by what the foreign worker has, but instead by the actual minimum education and experience requirements of the job at your company. So if you would normally recruit for the role listing a bachelor's degree and 3 years of experience, that falls short of EB2 and is EB3. Moving on to another key attestation when an employer files a perm. The offered wage must equal or exceed the prevailing wage. And Survey mentioned the concept of prevailing wages back with H-1Bs. Well, they come back to haunt us at perm. This attestation can be particularly problematic for science and research positions where we typically see that employer compensation falls below the DOL legally mandated prevailing wages. A way to deal with this is to use a non-DOL wage survey, but this approach is difficult in the perm context. And if the Department of Labor does not accept the alternate wage survey, then employers must adhere to the DOL prevailing wage in order to proceed with the green card process. Another key attestation is that the job opportunity was made clearly open to any U.S. worker pursuant to legally prescribed recruitment methods. And this relates back to the recruitment I was talking about earlier and ensures that employers actually engaged in the legally prescribed methods of recruitment for the prescribed time periods. Related to this, employers attest that U.S. workers who applied for the job were rejected for lawful job-related reasons. Now, the Department of Labor does not accept any and all reasons for rejecting applicants. For example, many real-world reasons, like this person simply is not a good fit in our group, are considered to be too subjective by the Department of Labor. So, we wouldn't be able to list those as reasons for rejection. So the employer, in an audit scenario, would have to demonstrate that all U.S. workers who applied for the job were rejected for only legally acceptable reasons. Finally, the employer attests that there has been no layoff of a U.S. worker within the area of intended employment in the occupation or a related occupation in the 6-month period prior to filing, or if there was such a layoff, that the company notified and considered these laid off U.S. workers of the perm job. And the takeaway there is that if you've had layoffs of U.S. workers in jobs that are similar to what your foreign national does, that can impact perm. So what does this all amount to? Well, the many legal requirements of perm, the current audit environment, and DOL processing times, which can sometimes exceed 1 year, make it a very long and tedious process. Moreover, perm-based green card applications will fall within EB2 or EB3. And as I mentioned, these categories can be backlogged for many individuals. This leads to overall longer wait times to obtain the green card. That said, the filing of a perm can provide a way to extend H-1B status beyond the initial 6 years, which makes it desirable for our H-1B visa holders. Moreover, it is the only green card option that's available to many individuals, unless, of course, they are fortunate enough to fall within an EB1 category. So now let's turn briefly to EB1. Individuals who are multinational managers or executives can obtain an EB1 green card process. And the eligibility criteria for this category are almost identical to the L1 criteria that Aisling reviewed earlier, except here, both the foreign and U.S. roles must be managerial or executive. So, whereas in the L1 context, you can mix and match by, for example, having a specialized knowledge role abroad and a managerial role in the U.S., that is not permissible at the green card stage, where you must show that both the foreign role held prior to transfer and the U.S. role are managerial or executive in nature. In addition, at the green card stage, there's no blanket option. So employers must apply directly to USCIS in the United States by filing an I-140 petition. However, you should note that an approved blanket petition can be leveraged as documentary evidence of the required corporate relationship. So it is beneficial to have a blanket. As I've mentioned, This multinational manager option does present a quote-unquote fast track to the green card because an approved firm is not required prior to the filing of the I-140. In other words, you don't need a perm and can go directly to the I-140. Moreover, due to the lack of backlogs in the EB1 category, the I-140 petition can be filed concurrently with Step 3 of the process, the adjustment of status, which leads to overall faster processing. Now, the next two slides group together 3 green card options. 2 of them are EB1, 1 of them is EB2. And these are commonly leveraged by scientists. First, we list aliens of extraordinary ability. Then we have the national interest waiver category, and finally the outstanding researcher category. These categories are similar to each other in that they require similar documentation to prove eligibility. Moreover, none of them require a perm labor certification and thus present faster processing. For those reasons, practitioners will often file all 3 types of petitions at the same time to obtain quote-unquote 3 bites of the apple, which increases the chances of success in at least one category. Now, to qualify as an alien of extraordinary ability, the petition must demonstrate very similar criteria to those outlined by Survey when she discussed the O1. Specifically, the foreign worker must possess a one-time major achievement, like the Nobel Prize, or heavily document that he or she meets 3 of 10 lesser criteria that evidence extraordinary ability. And these include, I'm not going to go through all of them, but some of them include publishing work in reputable journals, major original contributions to your field, holding leading or critical roles at distinguished institutions, winning industry awards or prizes, or commanding a high salary compared to your peers. Moving on to the national interest waiver category, which waives the perm requirement if one can show that their area of expertise is within the U.S. national interest. The eligibility criteria are a little different from extraordinary ability, but in practice we use the same types of documents to evidence that you meet the eligibility criteria. Specifically, to show that one's area is within the U.S. national interest, he or she must meet a 3-part test. First, the foreign national must plan on working in the U.S. in an area of substantial intrinsic merit. Second, the proposed impact of the foreign national's work must be national in scope. And third, waiving the labor certification requirement must benefit the national interests of the United States. Similarly, to qualify under the outstanding researcher category, one must show that they are recognized internationally as outstanding in the academic field through meeting 2 of 6 criteria. And these include, again, major awards showing that you've published materials, you've published scholarly or scientific articles, you've made major contributions to your field, etc. In addition, in the outstanding researcher category, the individual must possess 3 years of teaching or research experience in their academic field. And if the job offer is coming from a private employer, it needs to be a permanent or long-term research position, and the employer must employ at least 3 full-time researchers. So the eligibility criteria, we can all see that they're sort of similar and overlapping, but it's important to consider that there are some unique considerations for these categories that employers should be aware of. For example, the extraordinary ability and outstanding researcher categories fall under EB1 and thus present less backlogs, allowing for concurrent filing of the I-140 and adjustment of status. The national interest waiver process, on the other hand, falls under EB2. And we know that that can be backlogged for certain individuals, namely those born in India and China. Now, as a trade-off for these backlogs, however, you should note that it's generally easier to obtain approval under the national interest waiver because USCIS does not adjudicate the national interest standard as rigorously. It's still rigorous, but it's not as rigorous as the extraordinary ability and outstanding researcher standards. Finally, I'd like to note that the extraordinary ability and national interest waiver categories both allow for either employer or self-sponsorship. This means that the company may act as the petitioner, but it does not have to. And indeed, we do see many foreign nationals engage in their own independent green card processes wherein they sponsor themselves under these categories. Now, though we would usually recommend proceeding with employer sponsorship because it can strengthen the case that a foreign national is actually using his or her area of expertise, self-sponsorship can be desirable to an employer where the case is not very strong or where the company has budgetary concerns regarding proceedings. The outstanding researcher category does not allow for self-sponsorship, so there the employer does have to serve as the sponsor to proceed. So now that we've reviewed this range of green card options, I wanted to consider which options would work best for our fictional friends, Angela and Jack. As a threshold issue for Angela, we would have to determine whether she is subject to the J1 two-year home return requirement because she previously held J1 status. If she is not subject, then we can proceed to green card sponsorship. However, if she is, then she would either need to fulfill the requirement by remaining in her home country for at least 2 years or her country of last permanent residence, or she would need to obtain a waiver. Now, assuming we can overcome this issue, or that it's not an issue at all, because Angela has worked in a senior capacity for your company abroad for at least 1 year and is being considered for the senior position of senior scientist, she would likely qualify for a green card under the multinational manager category. And the biggest challenge there would be to ensure that her duties both abroad and in the U.S. are sufficiently managerial. If we determine that they are not, we could also consider the extraordinary ability, national interest, and outstanding researcher trifecta of options because she has quite an accomplished resume. She's worked in research positions in the past, and she performs work in an area that is arguably beneficial to the U.S. national interest, namely the research and discovery of nutritional supplements. Because Angela is a Canadian-UK citizen, she was likely born in either Canada or the UK, and thus would not be subject to green card backlogs in the EB1 or EB2 categories. This means an overall quicker process for her. From a cost perspective, it would be less costly for the employer to pursue the multinational manager green card. Thus, we would likely try to develop that option first, but use the other options as Plan B. The perm-based option is something we would not pursue for Angela, but would likely have to pursue for Jack, who does not meet the multinational manager criteria because he never worked for your company abroad and holds a more junior role. Moreover, I think we would all agree that Jack is not as advanced within his career and does not have the level of accomplishment we would need in order to establish eligibility under the extraordinary ability, national interest, or outstanding researcher categories. So here, Jack really illustrates the point that where all else fails, the perm-based option is usually a fallback option for the green card because it can be leveraged by many types of professionals at varying levels in their careers. For Jack, his perm-based green card process would fall under EB2 if the minimum requirements for the junior scientist role were listed as an advanced degree or as a bachelor's degree and at least 5 years of work experience, and if Jack possessed those qualifications. Now, we know from our hypothetical that Jack has a bachelor's degree but only 3 years of work experience. Therefore, he would not meet the requirements for an EB2 position, and his perm would inevitably fall under EB3. EB3 is backlogged for individuals born in Ireland, but EB2 is not. So strategically, we might recommend that the company wait to initiate the green card process until Jack could qualify under EB2 by being promoted into a more senior role and acquiring more years of qualifying work experience. Having exhausted 3 years of H-1B status, however, we could determine that Jack does not have the time to wait out this strategy and might be compelled to pursue an EB3 perm. So, poor Jack might get the raw end of the stick and have to endure a long EB3 perm-based green card process. So in summary, we've taken you through the longer-term green card options as well as the temporary non-immigrant visa options for both Angela and Jack, and it seems like some winners have emerged. For Angela, the L1 visa followed by the multinational manager green card option would probably prove to be the most expedient and cost-effective options, but she would be able to fall back on the O1 visa, especially if she were subject to the J1 2-year home return requirement. Moreover, Angela would be a candidate under the Extraordinary Ability, National Interest Waiver, and Outstanding Researcher categories. For Jack, since he currently holds H-1B status, he's not likely subject to the H-1B cap, and therefore an H-1B change of employer petition would likely be the best path for him. And on the green card side, we would follow that by a perm-based green card application. So we hope that these hypotheticals have enabled everyone listening today to understand the various interconnected considerations that go into visa sponsorship and that it's provided useful knowledge to everyone. That really concludes our overview in today's formal presentation. Please allow me to thank Aisling and Survi for running through all of these scenarios and visa options with us. Please also allow me to thank all of you for attending and your attention. And with that, I'd like to open it up to questions. We have a few more minutes for questions here. Let's see. Okay. So, first question I see here is that, okay, we have someone who's subject to the J1 2-year home residence requirement, who changed status from J1 to O1 and has been in the U.S. for several years in O1 status. Okay, so we'd like to consider her for a green card now. Do we need to do anything with respect to the J1 2-year home return requirement? That's a great question. Survi, do you want to take that?
Yeah, I'd be happy to.
Yeah.
So, as we mentioned, once you have that 2-year home residency requirement, you are barred from applying for a green card until you either meet that requirement or have it waived. So, if this person is in O1 status and they're not really planning to return home for 2 years and you want to keep them here, which I think is obviously the intent since you want to apply for a green card for them, there are ways to meet that requirement without going home for a 2-year long stretch. So that requirement of going home for 2 years doesn't mean you have to go home for 2 years consecutively. This person in O1 status can take trips over many years back to their home country or their country of last permanent residence and can accumulate 2 years over time, and they'd really have to document that period through passport, visa stamps, and any other proof they were physically present. And after they've accumulated 2 years, they have then met that requirement. So we see that. We see people who are in O1 status for 10 years or so, and during that 10-year period, they made multiple trips home, and it's added up to 2 years. Or alternatively, if they are eligible for a J1 visa waiver of that requirement, they could apply for a waiver, and if they get it, then they can be eligible to apply for the green card. And just so you know, the eligibility for a waiver is really a much longer conversation. It could really have its own webinar if it needed to. So we're not going to go in that right now, but it is possible to get a waiver in some circumstances.
Right, that would prove to be a more immediate solution, but it's a matter of getting the waiver.
Yeah.
Okay, I see another question has popped up here. What if someone is on an L1B and switches to L1A, can they later qualify for the multinational manager green card option? Okay, yeah, I can answer that. Yes, they can qualify for the multinational manager green card. So it all boils down to whether the employment abroad just prior to the transfer to the U.S. was managerial. So if it was, that preserves the multinational manager green card option, notwithstanding the fact that they initially transferred to the U.S. as an L1B, which is not managerial. So you can have, a managerial position abroad, transfer to the U.S. in a non-managerial role and work in that role for a few years in any status, L1B, H1B, and then if you're promoted into a managerial role while you're in the U.S., you can qualify for an L1A as well as a multinational manager green card. So intervening status, that's what we call it, like the intervening L1B does not necessarily knock you out of the multinational manager green card option. Okay, I think we might have time for one more. Okay, for Jack, you all mentioned that he could qualify under a 5-year J1 research scholar or H1B. Which of these do you think is better?
I'll take that one.
Okay.
So for an H1B position, usually it can be a temporary position or it could be something long-term. So that makes sense for an H1B if that junior scientist position is a long-term position. For the J1, I mentioned something about program sponsors specifically wanting assurance you intend to return home. So program sponsors will not approve Jack for a regular full-time position in J1 status. They really want to see that he has the intent to return home after the J1 program is over. So usually for J1 research scholar, you'll see that foreign nationals enroll in maybe like a postdoc position with a company or a visiting scientist, something like that, that really is temporary in nature and not for a full-time position. So for Jack, for the junior scientist, the H1B is the best option because it seems like it's an indefinite position.
Okay, great. If there are any other questions, we could be happy to answer them offline, but I think our webinar has to conclude now. So thank you all again for listening in, and we hope we've provided some valuable information today. Thank you.